For judgment, item 1.
Thus, upon due consideration of the case in its entirety, this court finds that the conclusion reached by the learned trial court that a conviction under 304 IPC is attracted instead of 302 IPC is found to be not supported by the evidence available on record. Accordingly, the impugned judgment and order is hereby set aside. However, instead of proceeding further into the matter, this court is of the considered view that the matter should be remanded back to the learned trial court, having regard to the provisions of Section 377, subsection 3 CRPC, or Section 418, subsection 3 of BNSS 2023, so that a reasonable opportunity may be given to the accused for showing cause as to why the sentence should not be enhanced as per the charged section. It is ordered accordingly. The accused for his conviction under 304 IPC by judgment and order dated so-and-so was sentenced to undergo rigorous imprisonment for a term of 7 years and to pay fine with a default clause by its sentence order dated so-and-so. Therefore, it may so happen that he has completed the term of his imprisonment by now. In order to verify the same, the registry of this court was asked to obtain information in this regard from the Special Superintendent, Central Jail, Aizawl. The said authority, via communication dated 14/5/2025, has written to the registrar that the accused person, according to their record, was received by the Central Jail from District Jail Lungle on transfer on 6/4/2018, and that he was released on expiry of the sentence on 14/10/2022. Under the above circumstance, the matter is remanded back to the learned trial court for fresh consideration as directed in the preceding paragraph and in accordance with law. The learned trial court shall secure the presence of the accused by issuing necessary process, including an arrest warrant if necessary. Upon the appearance of the accused, the learned trial court shall give due reasonable opportunity to the rival parties to present their respective case and thereafter bring the case to its logical conclusion in accordance with law. For the valuable assistance rendered by Mr. F. Liana, Learned Amicus Curiae, the Mizoram State Legal Service Authority shall pay him fees as per the rates fixed in this regard. A copy of the communication dated so and so from the Superintendent Jail is retained in the record and marked as X for identification. With the above observation and direction, the appeal stands disposed of.
Obliged.
Item 2 with 3.
Thus, upon due consideration of the case in its entirety, it cannot be said that the prosecution has been able to prove the case against the appellant with proof beyond reasonable doubt. Accordingly, the impugned judgment and order is found to be not sustainable, and the same is set aside. The appellants are directed to be released if not otherwise wanted in connection with any other case. With the above observation and direction, the appeal stands disposed of. Now, apart from that, I had also discussed about the section 65B, electronic evidence. So, which I have held that it's not in conformity with the relevant provision. And plus the evidence of the prosecution. All right. Okay.
Obliged.
Yes, any mention?
My Lord, I'd like to seek your lordship indulgence in making mention of item number 12.
Item 12.
My Lord, I have taken the consent of the other party. If the matter is listed on 5 June, my Lord.
5th June. Okay, Mr. Yantrima, learned senior counsel appearing for the appellant, submits that he has some personal difficulty to conduct the case today and prays that the matter be listed on 5th of June 2025. The said prayer is not objected to by the other side.
No objection, my
View
lord.
of above, list the matter on 5th of June.
Obliged.
Obliged.
Seek your lordship's indulgence in respect of this item number 13 on behalf of Mr. Vanan Haka, counsel for the respondent. My lord, he's having some medical emergency, so to say. His brother-in-law is in hospital, so that's why he could not make it today. If possible, if it can be taken up next week.
Okay, have you? Government side, have you informed the other side?
Yes, sir. It seems that he had taken consent before.
Okay. Mr. Vanan Haka, learned counsel for the respondent, is said to have some personal difficulty to appear before the court today. On a mention made on his behalf by Mr. Lal Fakoma, learned counsel, and not objected to by the other side, list the matter again in the next week.
My lord, deeply obliged.
Motion, item 4.
Yes.
Yes, may it please your lordship. Our matter pertains to the R&R rehabilitation and resettlement, which we are entitled to receive as per the Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013, my lord. The respondents have acquired our lands falling within the Dulte village, Khosol district, for which the compensation as per the first schedule to the 2013 Act was prepared. However, the entitlement for the rehabilitation and resettlement as per the second schedule to the 2013 Act has not been given to us till date, my lord. What happened was that the respondent number 5 had prepared R&R as per the second schedule to the 2013 Act. However, the respondents have issued numerous impugned minutes of meeting, notifications and orders, letters, for which the previously prepared R&R was to be converted as per the JICA entitlement matrix, my lord.
What is R&R?
Rehabilitation and resettlement, my lord.
You are supposed to get that in terms of the 2013 Act.
Yes, my lord, as per the second schedule to the 2013 Act, my lord.
And what are you offered then, now?
So what happened then was that the previously prepared R&R as per the Raffler Act of 2013 was prepared as per the JICA Act, the JICA entitlement matrix. However, be that as it may, we have not been given any R&R rehabilitation or resettlement till date.
Either under JICA
Either.
or either on the or
My
under
lord.
the 2013.
My lord. So RTI was filed and reply was received wherein the SPIO, which is also the respondent number 4, submitted that no rehabilitation and resettlement has been issued to the landowners or tenants living within Dulte village, my lord.
See, relief and rehabilitation is a different component
Yes,
apart from the normal compensation for acquisition of the land.
Yes, my lord.
Have you received that compensation?
As per the first schedule to the 2013, yes, my lord.
What is that first schedule?
First schedule is the manner in which compensation is to be calculated, my lord.
You have received that.
Yes, my lord.
Now, what are you supposed to receive?
Now
In
we
addition-
are supposed to receive the award as the entitlement for the rehabilitation and resettlement as per the second schedule to the 2013 Act, my lord.
Okay. Just a minute. We'll have a look at this. First schedule. 51. How many petitioners are before this court?
26 in total, my lord.
Okay. So you say that you have received as per the first schedule.
Yes, my lord.
In terms of 2013,
Yes, my lord.
and for the rehabilitation and resettlement, you are supposed to get under the second schedule.
Yes, my lord.
They have prepared under the JICA.
Yes, my lord.
So that also has not been given to you.
No, my lord.
What is the reason?
So the reason was that, if I may have your lordship attention to page number 131, annexion number 13A. This letter was issued by the SPIO, the respondent number 4, when the RTI was filed. The type copy is at page 132. So if I may read from paragraph number 2.
This is from whom?
This is from the NHIDCL, the respondent number 6 and 7, my lord.
Okay, to the...
To the Deputy Commissioner.
Yes, please read from
Yes.
which paragraph?
Paragraph number 2, page number 132, type copy.
Yes.
In this regard, kind reference is invited to Chapter 3 of the Ruffler Act 2013, which provides that the provisions of this section shall not apply in the case of projects that are linear in nature, such as those relating to railways, highways, major district roads, irrigation, canals, power lines, and the like. Copy of Chapter 3 of the Ruffler Act 2013 attached. Paragraph number 3. Since the project of NHIDCL are related to national highways and are linear in nature, the second and third schedule of the Ruffler Act 2013 will not be applicable. The land acquisition for the widening of NH06 is being done strictly in accordance with the NH Act 1956. Nowhere NHIDCL is paying R&R awards in the development of central funded NH projects in the northwestern states. Paragraph number 4. It is clarified that in an exceptional case, the resettlement and rehabilitations has been considered in the widening and upgradation 2 lanes of NH02, old NH54, Aizawl Tuipang Road on the basis of the impartite agreement amongst the Government of India, Government of Mizoram, and JICA, Japan International Cooperation Agency. The NH02 double laning project has been fully funded by JICA, whereas the projects on NH06 are being wholly funded by the central government and are exempted from R&R award as brought out in paragraph number 2 and 3 above.
This is the reason why they are not giving you.
Yes, my lord. So at page number 133, another letter was also attached by the respondent number 4 in the reply to the RTI. This is the impugned letter dated 23 November 2022. If I may read again, my lord, from paragraph number 2.
Yes.
This has reference to your letter at paragraph 1A, wherein an estimated amount rupees 523,00284.00 has been forwarded to this office for rehabilitation and resettlement. Paragraph number 3. In this regard, kindly refer to the decisions taken under the minutes of meeting of the Empowered Committee, wherein it was amply made clear by the Chairman Empowered Committee that R&R shall only be applicable for the JICA-funded projects of Aizawl Tuipang, NH54, that IC bypass, so and so. The same was also clarified to your good office by letter mentioned in paragraph 1C. Hence, the estimate submitted is not admissible. So, if I may have your lordship back to page number 132, paragraph number 2.
Page?
132.
Yes.
So in paragraph number 2, the kind reference is, paragraph 2 states that the kind reference is invited to chapter 3 of Ruffler Act of 2013.
Just a minute. From where are you reading?
Paragraph number 2,
Of
page 132.
1-3. Okay. Yes, please read.
In this regard, kind reference is invited to chapter 3 of the Ruffler Act. So chapter 3 of the Ruffler Act deals with different provisions, my lord. It deals with the special provision to safeguard food security.
Chapter 3.
Yes, my lord, of the Ruffler Act of 2013.
Safeguard food security.
Yes, my lord.
So what is it got to do with this case?
Yes, my lord, exactly.
So it might be a typing mistake. Could it be a typing mistake?
So if I may have your kind attention to the proviso of the section 10, chapter 3, my lord. Section 10.
Yes.
So the proviso states that provided that the provisions of this section shall not apply in the case projects that are linear in nature, such as those relating to railways, highways, major district roads, irrigation canals, power lines, and the like. So the...
No, I think you please read from the section 10 itself. Let us try to understand
Yes,
this.
my lord. Special provisions, section 10, special provision to safeguard food security. Subsection 1, save as otherwise provided in subsection 2, no irrigated multi-crop land shall be acquired under this act. Subsection 2, such land may be acquired subject to the condition that it is being done under exceptional circumstances as demonstrable last resort, where the acquisition of the land referred to in subsection 1 shall in aggregate for all projects in the districts or state in no case exceed such limit as may be notified by the appropriate government considering the relevant state specific factors and circumstances. Subsection 3. Whenever multi-crop irrigated land is acquired under subsection 2, an equivalent area of cultivable wasteland shall be developed for agricultural purpose, or an amount equivalent to the value of the land acquired shall be deposited with the appropriate government for investment in agriculture for enhancing food security. Subsection 4. In a case not falling under subsection 1, the acquisition of the agricultural land in aggregate for all projects in a district of state or state shall in no case exceed such limit of the total net sown area of that district or state as may be notified by the appropriate government, provided that the provisions of this section shall not apply in the case of projects that are linear in nature, such as those relating to railways, highways, major district roads, irrigation canals, power lines, and the like. So basing upon the proviso, the respondent number 6 and 7 has issued impugned letter dated 20 October 2022, wherein it referred to paragraph number 3 at page 132, my lord. If I may read again.
Yes.
Since the projects of NHIDCL are related to national highways and are linear in nature, the second and third schedule of the Ruffler Act 2013 will not be applicable. So, my lord, basing upon the proviso in section 10 of the chapter 3, the respondents have deflected the entitlement of the petitioners, my lord. Which clearly has nothing to do with the rehabilitation and resettlement itself. Yes, my lord. In the meantime, my lord, I would like to bring to your kind notice that I have made some 3 clerical mistake inadvertently at page number 37, my lord. The prayer portion. If I may be kindly allowed to exchange the pages, my lord, just one. At page number 37, my lord. Yes, my lord. So 9th line from the top. 2011-2022 should be 2010-2022, my lord, the impugned letter. And 3rd line from the bottom, 2011-2022 should be 2010-2022. Yes, my lord. My lord. My lord. Yes, my lord. Understood. My lord.
File a small application, will be allowed. Please write down her, Ms. Valentina Naldin-Pui, learned counsel for the petitioners, who submits that the petitioners are owners of their respective land located at Dulte village in the district of Kozol, Mizoram, which was acquired by the respondents for construction of NH6 in the stretch of land from KM 54.6 to KM 69.015. Stop. The petitioners have been paid compensation for the value of the land and asset value along with the solatium in terms of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013, bracket Act of 2013. Stop. Apart from the said compensation, the petitioners are entitled to receive compensation under Schedule 2, is it? Schedule B?
Second schedule.
Under the second schedule of the Act of 2013 towards rehabilitation and resettlement. Stop. Initially, the respondent authorities calculated the amount of compensation payable to the petitioners not under the Act of 2013, but under the JICA, GIS.
My lord,
Yes.
if I may, initially the respondent authorities prepared the draft award as per the 2013
Okay.
Act.
Okay. Please read one sentence then, initially. No, not under, it'll be, from there you cancel. Under the Act of 2013, but subsequently modified the calculation under the Japan International Cooperation Agency bracket JICA, JICA guidelines. Stop. However, the calculated amount has not been paid to the petitioners till date. And therefore, the petitioners being aggrieved are before this court. Stop. Ms. Valentina Laldinpuri, Learned Counsel, has drawn the attention of this court to the communications dated 2010-2022, bracket annexure 13, and 23/11/2022, annexure. Okay, the first one is 13A. Then now it will be 13B, capital A, capital B, okay? Wherein the authority in the NHIDCL had written to the Deputy Commissioner, Kozal District, stating that in view of the project of NHIDCL being related to national highways and are linear in nature, the second and third schedule of the Act of 2013 will not be applicable. Stop. Specific reference has been made to Chapter 3 of the Act of 2013. Stop. She submits that. There is no basis on the stand taken by the respondent authorities in the NHIDCL. Since Chapter 3 pertains to special provisions to safeguard food security and will not apply to the present case. Stop. She therefore submits that direction may be issued to the respondent authorities to pay the petitioners their due compensation towards resettlement and rehabilitation. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. Zarem Sangpui, learned CGC, accepts notice on behalf of respondent number 1. Stop. Ms. Mary L. Kiante, learned government advocate, accepts notice on behalf of respondent numbers 2 and 3.
Fine. Nothing.
You were saying anything about 5?
No, Your Lordship, my learned friend is saying that you should receive for 5 also, but then the number 5 is the subordinate of Kala, so they are SDO civil, no
Okay.
doubt. Yes.
So who will, what about NHIDCL? They have a standing counsel? Is it Mr.
Samuel.
Then, right, Mr. Samuel Vanalthia, that's Sangte, learned counsel accepts notice on behalf of respondent numbers 6 and 7. Stop. As such, formal notice is not required to be served upon the respondents who are represented today. Petitioner shall, however, furnish requisite copies of the writ petition to the learned counsels appearing today, if not already done. Stop. Petitioners to take steps for service of notice upon the respondent numbers 4 and 5. How will you take?
Through registered post, my lord.
By registered post with ADD within 3 days, 3 working days. List the matter again after 4 weeks.
Much obliged.
Orders item 10.
My lord, I will file my objection for the respondents 1 and 2 by next week. Objection to the IA.
What is this IA?
This is regarding the delay of 616 days, Your Lordship, by filing the connected appeal.
You are for which party?
I am for the respondent 1 and 2, my lord.
Claimant?
Claimant, my lord.
What about others? Any other respondents?
Yes, Your Lordship, 4 and 5, they've already filed their affidavit.
Who are they?
They are the
Owner?
yes, Lord.
Driver owner?
No, driver is not represented till today.
They have already filed.
4 and 5, they have already filed, Your Lordship.
Who is their counsel?
Mr.
Mr. Kelaldinian.
He has not come today. Okay. Mr. C. Planthiangima, learned counsel for the respondent numbers 1 and 2, submits that he may be given a week's time to file his objection to the IA. Stop. Praise aloud. List the matter again after a week. Mr. John L. Tochong, learned counsel for the applicant, is present.
Obliged.
Item 11.
Yes, Mr. Ramzawa? You have filed an IA.
Lordship, we filed IS 77 of 2025 for implement of Srimati Jubilee Chuohang, who was making construction and who has been continuing. We have sought for implement of the said Jubilee Chuohang as respondent number 5A in the connected RFA number 1 of 2025.
Will it be permissible at this stage?
At this stage, Your Lordship, Your Lordship, at any stage, what is stated in the
Anyway, you will issue notice today, I think. Mr. Ricky, you are there?
Yes, my lord.
You may also would like to have a look on this issue.
Yes, my lord.
Heard Mr. Sila Ramzao, learned senior counsel, assisted by Mr. Stephen Lalbotsaya for the applicant. There's only one applicant, is it? No, applicants who submits that by filing this application under Order 1, Rule 10, bracket 2, read with Section 151 CPC, the applicants pray for implement of Srimati Jubilee E. Chauhang as respondent number 5, capital A, in the connected RFA number 1 of 2025. To stop, the learned senior counsel submits that implement of the said person is required since she is undergoing, she is making construction and development in the suit land concerned. Next para, in view of above, issue notice returnable within a week. Mr. Ricky J.H.
Ricky Lalrotfela, my lord.
Oh, there's no J.H.
There is JH, my lord. JH Ricky Lalrotfela.
Why do you make your name so complicated?
It's hereditary, my lord.
Mr. So you intend to pass it on? Hereditary.
JH, yes.
Okay. Mr. Ricky J.H. Mr. J.H. Ricky Lalrotfela, learned counsel, appears and accepts notice on behalf of the respondent numbers 1, 2, 3, and 1 to 5.
1 to 5, my lord.
1 to 5. While Mr. Samuel Vanoshi Sangte, learned additional advocate general, accepts notice on behalf of respondent numbers 6 to 10. Stop, as such notice is complete upon the respondents and no formal notice will be required. Applicant to serve requisite copies of the application to the learned counsels appearing today, if not already done. So stop. On the next court date, the learned senior counsel for the applicant shall address the court as to whether implement of a person who was not a party in the civil suit before the trial court can be done at the appellate stage. The respondents also will be at liberty to file their written objection, if so advised. This is the matter again on 23rd of May, 2025. Yes.
Lordship, there's another IA 76 of 2025.
That is for?
That is for interim injunction.
But that will have to be, first we'll have to seek implement.
Lordship, interim injunction has been filed because of the fact that the early application, which the applicant
This also will
filed.
issue notice. We cannot pass any order today.
All right.
Heard Mr. C. Lal Ramzawal, learned senior counsel, assisted by Mr. Stephen Lal Botsaya for the applicants, who submits that by filing this application under Order 39, Rule 1, read with Section 151 CPC, the applicants pray for grant of interim injunction against Srimati Jubilee E. Chauhang, who is sought to be impleaded as respondent number 5A, White IA number 77, IAC number 77 of 2025. Next para, issue notice. Rest the same, okay? Parties are appearing also, same date.
Lordship.
All right.
In the meantime, Lordship, whether it's permissible to maintain status quo?
No. Let us consider the application for
All right.
impleadment first. All right.
No, please.
Item, admission, item 5.
My lord, in this matter, I am led by my senior Mr. A.R. Malhotra. He's having some personal difficulty, my lord. So the matter may be taken up after 2 weeks.
Mr. A. Malhotra, learned counsel for the respondent, is said to have some personal difficulties today on the prayer made on his behalf by Mr.
Sitlantian.
Sitlan Thianglima, and not objected to by the other side. List the matter again after 2 weeks.
Obliged.
Item 6.
May I please, Your Lordship, my lord, pleadings are complete in this case, and if Your Lordship permits, it may be taken up as admission hearing on 6th of June, my lord. Today, I'm having a personal difficulty myself.
Just a minute. Court Master, just come here.
One. WPC.
Okay, on any other available date, my lord.
Who's for the other side?
Your Lordship, I'm appearing on behalf of the state respondent.
Okay. Okay, on 10th of June then. Okay.
Yes, ma'am.
Parties are represented by the respective councils and they submit that pleadings are complete and the matter may be listed for admission hearing. As paid for by Mr.
Lalbirno.
Birno Hanamte, learned counsel for the petitioners, list the matter on 10th of June 2025.
Obliged, my lord.
Much obliged.
Item 7.
My lord, I have received a copy of the counter affidavit filed by the respondent number 4, my lord. If I may be given a week's time to file a reply affidavit, if so advised.
Okay. Mr. Seetlan Thianghima, learned counsel for the petitioner, submits that he has received a copy of the counter affidavit, but he may be given a week's time to go through the same and to file a rejoinder if found necessary. In view of above, matter stands adjourned for a week. Petitioner may file rejoinder affidavit in the meantime, if so advised.
I'm obliged.
Item 8.
Please, Your Lordship, I'm appearing on behalf of the state respondents, and the matter was last listed on the 28th of March 2025. And as of today, Your Lordship, I'm yet to receive instructions.
Yes, what is the matter? Termination,
My lord,
languages
the matter is claiming the unpaid salary
from,
from the government.
you're a teacher in
I'm a
Radha
teacher.
Mohan High School,
My lord, yes,
Kamalanagar,
Kamalanagar.
Kalamanagar, or Kamalanagar. Which one?
Kamalanagar, it seems. Kamalanagar.
Kamlan.
The other day also we were this name came up the other day also.
In pair, Your Lordship, in pair number 3, it is written as Kalamanagar. And then in pair number 1, it is written as Kamalanagar.
It seems Kamalanagar.
What is that? Kamala is orange. Kamal is lotus. Then Kamala is again the mother of late Mrs. Indira Gandhi. So why they have given this name?
That
You don't know.
I have no idea, my lord. That Kamalanagar.
They say that it is because of it was the name of the mother of late Indira Gandhi. Mr. S.K. Mehdi was here the other day, CGC.
My lord.
He stood up, he said correct. Immediately he stood up and he said correct. But today I find a different spelling. This is Kalamanagar. So this might relate to late President Abdul Kalam also. Kamalanagar. Any document to show that name of the school? Yes, it's Kamalanagar. How much time?
Your Lordship, 3 weeks time may be granted.
Okay. Parties are represented by their respective counsels. Ms. Lalun Hui, learned government advocate, submits that she is yet to receive instructions in the matter, and therefore she may be granted further 3 weeks' time to obtain instructions and to file counter affidavit. To stop, the matter pertains to claim for payment of back wages by the petitioner, who is a teacher of Radha Mohan High School, Kamalanagar, Roman 4, Longklai district. To stop, the respondents shall ensure that counter affidavits filed by the next date. Or appropriate instructions in this regard should be given to the London government advocate to apprise the court as to why such payment has not been made. Registry to list accordingly.
Much obliged, Your Lordship.
Item 9.
May it please, Your Lordship.
Yeah.
My Lord, if I may be allowed 2 weeks' time to file my WO objections again in the IA. The applicant in this IA is seeking for impleachment, and certain developments have taken place which will need to be properly annexed.
IAS come for the first time,
Second time, my Lord.
but there's no order.
In the last court order, at that point of time, one RFA.
Who has filed the IA?
My learned friend here.
I filed the IA, my lord.
You are for the petitioner?
I'm the applicant because
I'm the petitioner.
intervention.
Petitioner. There's no respondent.
Respondent would be the state originally.
Private party intervener, my lord.
Okay, okay. IA is thicker than your writ petition.
Yes, yes, because I have to produce all the relevant documents.
Huh?
So at that point of time, Your Lordship, in the IA, what my learned friend was saying is that one RFA was pending, but that has been disposed of as on date. So in light of that, I would like to file my objections.
So Mr. Ramenga says that if you can file 10 pages writ petition, I can file 50 pages IA. How much time?
If it can come up again on the 29th, if possible, Your Lordship.
Okay, as paid for by Mr. Lal Fakoma, learned counsel for the petitioner, oblique respondent in the IA, list the matter on 29th of May 2025. Stop in the meantime, liberty is granted to the petitioner to file objection to the IA, if so advised. Mr. Bilal Ramenga is present for the applicant, and Ms. Caroline Kelly-Morby, learned government advocate, is present for the state respondents. Okay. Something to do with the compensation.
Something. That. What happened was that I had purchased the property in 2010. So in 2018, the land was subsequently acquired. And in 2000, I believe my learned friend may correct me on the year. I believe in 2021, they filed a civil suit challenging my title. So that case was dismissed on the grounds of limitation. And then they approached this honorable court by filing that RFA, which now has been disposed of as well.
Disposed means dismissed?
It was remanded for fresh adjudication on the question of limitation after framing of an issue on that point. So
pending disposal of that particular case.
Yes, Your Lordship.
The applicant says that let the money be there.
Yes.
You say,
basically,
I want the money.
Yes.
You say, I want the money, give me the money.
Yes.
And the authority says that there's a letter.
Yes. No legal legs to stand on, but yet there's a letter.
So what is the development in that case which is pending?
It's listed for hearing. So by 29th, the hearing would be concluded. That's right.
That's why you asked for 29.
Yes, Your Lordship. So at least we have some positive information to.
All right, fine. Okay, it'll be fine. No problem. Okay.